I've got 9 o'clock. Do y'all want to get started?
Yes, I think that's fine. I'm sure Jarvis will join us momentarily. I see Dr. Kerrigan. I see what I think is Dr. Drake, but I don't see the video.
All right, then let's get started. It's 9 a.m. on 7/24/2020. We're going to call the quarterly meeting of the Texas Forensic Science Commission to order. As an initial action, I want to read a statement. Due to the Governor Greg Abbott's March 13th, 2020 proclamation of a state of disaster affecting all counties in Texas due to the coronavirus, which was extended on July 2nd, 2020, as well as the Governor's March 16th, 2020 suspension of certain provisions of the Texas Open Meetings Act, the Texas Forensic Science Commission meets virtually today as authorized under Texas Government Code Section 551.125. First agenda item is a roll call for members. I'm Jeffrey Barnard. I'm here. Bruce Badoli.
You're muted, Bruce.
Here. Dr. Jasmine Drake. Dr. Sarah Kerrigan.
Here.
Jarvis Parsons. Pat Johnson.
Here.
Mark Daniel.
Here.
Dr. Patrick Fazzini.
Here.
And Dr. Nancy Downing.
Here.
All right, so it looks like we may be missing two members, Dr. Jasmine Drake and Mr. Jarvis Parsons. I see Dr. Drake.
There she is. Looks like her mic and camera are just off.
Okay.
Why don't we
All
give her?
right.
There she is.
Yes, I'm on.
Okay. All right. All right. So the second agenda item is the instructions for public participation in meeting process. Lee.
Yeah, so if anybody wants to ask a question or provide a comment throughout the meeting, just type it in the little chat box. And if you have any technical issues, please reach out to Steve Miller. You can find him in the chat box as well. He can help you with any technical issues. If you don't get to speak during the meeting and you would like to, we have a designated comment period at the end of the agenda where we'll unmute everyone at that point. So if you have any questions, let me know.
All right. Agenda item 3 is to review and adopt the minutes from the June 11th, 2020 Complaint Screening Committee meeting. So is there a motion?
I've reviewed them. I believe they're accurate. I would make a motion to approve.
Is there a second? All those in favor say aye.
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 Opposed? The motion passes unanimously. The next portion is to review and adopt the minutes from the June 12th, 2020 quarterly meeting. Do I have a motion regarding that?
Doctor, same motion to approve and adopt.
Do I have a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Sorry, opposed? All right, that motion's passed. The fourth agenda item is the office administrative update. Lynn?
Sorry about that. Okay, so I'm unmuted. You can see in your meeting materials that we have included the fiscal year 2020 budget status report for the fourth quarter. And we've also included the budgetary reductions that the governor's office and the legislature has requested, which currently is at 5%. So does anyone have any questions about those items? I would request that the commission approve the budget through a motion with those reductions, because the original budget that you approved did not have the reduced amount in it. So if we could get a motion, that'd be great.
So do I have a motion to accept the final budget, which includes the request from the governor to reduce the budget by 5%?
So moved.
Second,
Second.
all those in favor say aye.
Aye. Aye.
Aye.
Any opposed? The motion carries. The fifth agenda item is an update on the statistics course examination administration and a list of the qualifying courses. Lynn?
So there are a couple different components to this. As you know, Dr. Spiegelman passed away unexpectedly, and so we had some students who were midstream in that course at Texas A&M. One student completed the course and took the exam with Dr. Longnecker, who's actually the author of the textbook that Cliff used. So Texas A&M has been helpful to us in trying to facilitate resolution for those who were close to taking the test, and assigning a graduate student to work with folks on any questions they may have. So that's been helpful. Also, Sam Houston coincidentally was running a summer session statistics course that Dr. Busini's teaching. And so we had a number of students enroll in that course. That course ends in about a week's time, and at the very end of July. So Dr. Busini is working the students through that process. It is not set lectures, but rather a series that people can take whenever it's convenient for them. So we had a number of folks sign up for that. So that's been helpful. And then the other issue that I wanted to come back around, there are actually two more issues. One is that, as you recall, the nonprofit associated with NMS had created a statistics course, and the first course they ran, from what Dr. Logan said, and I believe Dr. Logan's on the line, so he can speak to this as well. They had run it in person, but then toward the end, when COVID hit, they switched to an online method for teaching. And I believe the course they're going to run in the fall as an option will move online entirely due to COVID in part. So I don't think they have the link to that course option up yet, but they will. Dr. Logan, are you on the line?
Yes, I am.
Would you, is there something you'd like to add with respect to this?
Sure. So we did run that course. It started in January. It's a 15-week credit course. The content was previously sent to the commission. So we had 2 students complete that program. The exam ended up being done in person since it was manageable with 2 students, even though, as Lynn said, the latter part was delivered online. We are scheduling the program entirely online starting in mid-October. I hope to have dates within a few days, and I'll share the details with TACLAT and with the commission once we have the dates.
Okay, thank you, Dr. Logan. The other thing is that most of you are probably familiar with CSAFE, which is a consortium of universities that do work in the area of statistics and forensic science. And they are in the process of developing a course sort of following off of the work that Cliff did, but using various faculty members. And they've sent me sort of a draft outline of it, and I'll circulate that. I think their draft just got finalized yesterday, but I'll circulate that for folks to take a look at as well. So what we're trying to do is offer options for people that they can do remotely and that are directly relevant to their work, as opposed to just random statistics courses that can be taken at university. So between, I think, the offerings at Sam Houston, what NMS is doing, what CSAFE is going to bring online, we should have people covered. Any questions about that? I don't know, Dr. Busini, do you want to say anything about your course and how that's going?
Yes, so basically it's a 4-week course, and it's going to finish in 1 week. I think we have about 13 students, practitioners, I mean, on the top of some of our students at Sam Houston State University. One thing that I'm very interested in is to receive feedback. We automatically receive, we ask students to provide feedback, but I would like even to have a subsequent feedback after they get the license, and basically to know if our course is useful in the light of the licensing requirements, which I think it is, but I really would like to hear from the students. So it would be great if we can reach out to them in some time to check that.
I would be happy to help with, you know, a Survey Monkey type tool for anyone who goes through the course to see what they found helpful, what else they'd like to see. We could probably do the same thing for the NMS course and any other courses that we have that we're providing links to, so we can see what people find helpful, and you know, what things are more difficult. Because I know, like, just in talking to the faculty at CSAFE, they were asking, you know, do you really think they need X, Y, or Z? And I just don't really know. So I think that it'd be nice to get the feedback from folks. I know, you know, with Cliff's course, there were some comments about relevance and whether it was just pretty dry in terms of delivery. So I think the other faculty members who are engaging in this are trying to really make it as engaging as possible, so that somebody said at the TACLID meeting yesterday, I said, so that people will want to take the course. And they said, well, I think that's a little ambitious. So they'll be a little bit less dreading the course. It might be even a better thing to shoot for. So statistics are hard, and, you know, it's hard. A lot of people perceive it as hard. So to the extent we can relate it to folks' day-to-day work, that'll be helpful. So thank you to Sam Houston for jumping in and helping us address that very acute issue we had in the wake of Dr. So we appreciate that.
All right, Lynn, I'm getting a call from one of the court members. I'm going to have to step out and take that. Can Mr. Daniels technically run the complaint screening while I step out?
Yes,
To call for a motion?
Yes, as long as we have a quorum, which I see we do. So I think,
Okay.
Mark Daniels' agenda item, that's fine.
Yeah, it shouldn't take me long. I'll be.
We're back. Our 6th item today is our pending complaints and disclosures, I guess, since our last meeting, which has been just a little over a month ago. And the complaint review committee has not met since June. We are so good we can do our work without meeting. But there's 45 minutes allotted on the agenda. I think we can get through this in probably 30. And the first item actually comes out of the Houston Principal Science Center. There was a crime scene investigator, last name Puff, who provided some testimony in 3 cases actually, that probably stepped a little outside of his expertise. He really was a matter of semantics. He made a representation that there was a match on some shoes, and the lab said it probably should have been cannot be excluded. He also sought to do some sequence of events and steps with shoes using blood shoe prints. He is no longer employed with the lab. The lab essentially made changes in employment. They now provide some testimony and training. Staff had made a recommendation that there would be no further action in light of all that's done, which I'm actually okay with. So any comments, questions, or concerns by commission members?
Mark, I have a
Yes.
couple of questions. This is Pat.
Please.
Okay. the corrective actions that the labs indicated, I think are very good, but it seems to me like there were two issues here. One is the crime scene investigator is testifying to footwear comparisons that he's not qualified to, and they identified that mistake. But the second thing is, as I read his report, nowhere in his report does he mention anything about making footwear comparisons. He talks about photographs and his observations at the scene and so forth. Well, it seems to me like the issue needs to be addressed. Testifying outside his lane, he's testifying to material that's not in his lab report. And I know the training that I was used to, you're trained to stay within the test results that you have reported. So I'd like the lab to address that issue if they would.
We have two witnesses from the lab who are able to talk to this, Peter Stout being one of them, and Erica Zemak, who is the head of the quality division. So maybe we just give them a second to unmute their lines. Erica and Peter, are you there?
Yeah, sorry. Hi, this is Erica. Yes, I mean, I agree with the statement in the sense that he did testify beyond that which was captured in his report. I think that's actually, part of the problem. I agree, right? I think that if the report had language similar to that in the testimony, we would have had eyes on the issue sooner, if that makes sense. When that report was reviewed, we would have had the opportunity to identify that this might be an issue. But because it wasn't in the lab report, we didn't have eyes on it, I would say, until the testimony took place. But I agree with the comment.
Erica, can I ask you a question?
Sure.
We get a volume of materials in each of these complaints and review them. And there was one that said he was terminated. Another place that said he's simply no longer with the lab. Was he terminated?
No, he voluntarily left our laboratory.
What's he doing now? Do you know?
I don't have any direct knowledge, but my understanding is that he left our laboratory to pursue a career outside of the forensics field.
Yeah, Mark, what we had on his out brief is he went into disaster preparedness or something like that. He'd been in a degree program for that. To the best of my knowledge, he's still in the state, but that's what we know is he's departed the forensic realm.
Well, as a possible action, maybe we can take no further action with a letter to the Hughes Forensic Science Center that addresses both things Pat brought up. Number one, he testified outside the scope of his expertise. Number two, he offered facts and conclusions outside the scope of what he included in his report. How does that sound, Pat?
Yeah, that's fine.
Would you want to make that as a motion and take no further action with a letter to the lab addressing those two issues?
Yes, I make that motion.
We have a motion before we have a second.
Second.
We have a motion by Pat Johnson, second by Dr. Brazini. All in favor, say aye.
Aye.
Aye. Aye. Opposed indicate by saying no. I see Dr. Bernard has come back, so I'm going to turn this back over to him. Dr. Bernard, we're on the second self-disclosure. It's item number 2037. If you want, I can pick it up from there. You tell me how you want to do it.
You just completed the Houston Forensic Science Center?
Yes, sir.
Okay. So the second item for discussion is the NMS self-disclosure. So Mr. Daniel, you want to present it?
Yes, sir. It's item 2037. It's a self-disclosure for NMS out of Pennsylvania concerning an incident where the lab had issued a tox report concerning blood, plasma, and serum. The practice had extended from back in October of 19 all the way up to the first part of May, and they were essentially using invalidated calibration that had impact on approximately 1,100, well, exactly 1,104 cases. The staff had turned this over to Dr. Drake to to review, and she had done some work on it. She had several findings she made. One, she felt like the analyst should have referred to other validated methods when adding it to another instrument to ensure all the parameters were consistent and correct. She indicated in her experience that was always helpful. She also felt like deviation from the method or using a new method without some type of supervisory approval should be strictly prohibited. But then finally, she found in view of the Excel spreadsheets that all the concentrations versus the correct reported versus corrected, using the correct calibration method, there were very, very minor changes in the two values, which means they wouldn't differ substantially. But she did feel like the actions were somewhat questionable. Staff had made a recommendation to refer the commissioners with expertise in validation and calibration. Kind of already done that with Dr. Drake. I guess a question from my standpoint is, do we want to defer to other commissioners? We've already had her findings, or something else to be brought to our attention. That's a question, not a motion.
Dr. Kerrigan has looked at it, and we have on the line Dr. Rob Middleberg, who is familiar with this particular situation, and also MJ Menendez from NMS. So we're well represented from NMS for follow-up questions, and I think that there were a couple of questions that Dr. Kerrigan had, so I want to make sure that we give her a chance. And I think they probably follow on what Dr. Drake had also noted when she looked at it.
Yeah, so I won't repeat that. I think NMS have outlined very clearly in the documentation what transpired when the linear calibration was used instead of the validated quadratic. And as Dr. Drake pointed out, from an interpretive standpoint, really none of the cases are affected. So in other words, the small changes that existed in the quantitative measurements would not have changed the interpretation of those test results. However, when you look at the 1,104 cases that were in Texas, there were many more in total. There were about 146 pages of quant results that we were provided, but only 1,104 were in Texas. Of those 1,104, only 11 were outside of the original measurement uncertainty for ante-mortem living subjects, which were mostly DUIDs, or outside of a 20% range for the post-mortem cases from deceased persons. So the only thing that I would add, or the only request that I would make, is that they reissue reports in those 11 cases, because obviously the fact that the interpretive results are no different, they will be interpreted the same. The test result was actually outside of the original sort of range or parameters. So I don't think reissuing 11 reports is a heavy lift. I think we got clear documentation. That's the only thing that I would add.
This is Rob Middleberg. That's not an issue, and we can do that post haste.
Well, which I guess would beg a question: do we take no further action, or we take action in the lab to amend those 11 reports and then close the matter on receipt of that's been done?
Mark, I think we can take no further action. Well, we can tell them that the request is that they reissue those 11 reports, and that other than that, absent further material information, no further action is necessary. We can do that. I think we can wrap it up. I don't think we need to hold on to it for another meeting.
Let's do that, and I'll make that form of a motion.
All right, the
Second.
motion has been made for no further action. Is there any further discussion? All right, do I have a second?
Second.
Dr. Kerrigan, second.
All right, all those in favor say aye.
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 Opposed? All right, that being unanimous, the motion carries for no further action. Mr. Daniel?
Yes, sir. That brings us to our third self-disclosure item, 20.40. It's self-disclosure to DPS Austin, trace evidence section. There was some evidence connected to the case out of Pflugerville where evidently one hair sample, item of hair was lost. The problem came, the analyst, Katrina Battle, had evidently in the processing lost the hair, but there was renumbering of the evidentiary items to indicate that it had not been lost. It did not have much substantial effect on the criminal case. I believe this battle was terminated on the 22nd of June, the 29th actually, by not responding. Staff's recommendation was to investigate the self-disclosure, determine if the laboratory professional conduct finding is reported, which may need a separate panel to do that. Any questions or comments, concerns? I'm prepared to make that form of motion.
Any further discussion?
Mark, I'll recuse on this and the other three DPS self-disclosures.
Got it.
All right, so is there a second to the motion to create an investigative panel?
A second.
All right, all those in favor, say aye.
Aye.
Opposed? One abstention. All right, the motion carries. So now we need to pick 3 commissioners to be involved in this investigative panel. Since Jarvis is not going to make it, I think that he's basically volunteered.
I do volunteer too.
Doctor, I'll volunteer also.
Okay, so we have Mr. Daniel, Mr. Parsons, and Dr. Bazzini as part of the investigative panel.
I'll make that as a motion.
Yeah, I guess we do need a motion to accept that panel. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? All right, motion carries.
Which will bring us to our next self-disclosure from DPS also. It's a 20.41. It's a matter of shipping. Houston DPS, a ship container down to DPS Weslaco for insourcing. The box arrived damaged and missing one controlled substance case item. They had done a pretty good job trying to trace back with video and otherwise of being unpacked, how it may have happened. Just arrived damaged, best I could tell. They notified all stakeholders. They're developing new guidance and training for packaging and shipping. Staff had made a recommendation, no further action in light of their review and the root cause analysis, what they've done to correct it. Any questions, comments, or concerns? If not, I'll make that in the form of a motion, no further action in light of the remediation work having been done by DPS.
Okay, is there a second?
Second.
This meeting is being recorded.
I don't know what that was, but we've got a second. So all those in favor say aye.
Aye.
Opposed? All right, seeing as there are no objections, the motion carries.
Which will bring us to our 5th self-disclosure. It also comes from DPS. Byard involved in expanded measurement uncertainty measurements concerning a quantitative analysis. One was done by a percentage calculation on methamphetamine, and then with regard to coding, it was milligrams per milliliter. There was a 2012 final study found expanded measurement uncertainty was about 9.25%. If I'm just completely honest, I had a difficult time actually understanding what the issue was. Maybe someone with a greater level of scientific lab knowledge could help us with that. Staff recommend no further action given the recommendations from statisticians, implementation of expanded measurement uncertainty. So Would somebody like to jump in and explain this a little bit better to a layman?
So I don't mind jumping in, but maybe Dr. Bazzini can add to this as well if he chooses. So essentially this pertains to the quantification of methamphetamine and codeine at DPS. They'd established the uncertainty budgets and the expanded uncertainty, which is a requirement for their accreditation under 17025. The guidelines that you get from the accrediting body are not necessarily prescriptive in terms of how you put together your uncertainty budget. It's not necessarily standardized. And it appears that there was a small correction that was necessary upon re-review of the budget, which related to the probability distribution that was being used and the shape of the distribution for one of the elements in the uncertainty budget. So essentially it just slightly increases the range of the uncertainty budget because the parameters of this triangular distribution were not correctly assigned during the original uncertainty budget. After looking at this, I don't think there's any further action to take. I think that it's clear when you look at uncertainty budgets between different labs, they take very different approaches. They take a fundamental approach in terms of following the NIST STEP approach and the GUM method, the guidance to uncertainty of measurement. But because we don't have very prescriptive guidelines on how to do this, there is quite a lot of discretion between labs. In fact, if you took two different labs, you would probably find that their absolute approach to uncertainty of measurement was slightly different, and that's permissible under the accreditation guidelines. You just have to have something that's justifiable. So I don't find anything grossly troubling about this. I don't believe there's any additional action to take. Dr. Bazzini, do you have anything extra to add?
I can only second what you said. Yeah, I agree.
Well, then I will make that in the form of a motion to take no further action.
All right, is there a second?
Second.
All those in favor, say aye.
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 Opposed? A motion carries.
Which would bring us to our next item, that's self-disclosure 20.43, came out of DPS Tyler, out of the toxic section. There was a negative result for blood in the case, and they found out it actually never been opened by the analyst. It actually cleared technical review also. When questioned, the analyst fell on the sword, so I just don't remember it. They interviewed all the analysts and technical reviewers. They did a case review, the analyst's work, no additional problems or similar circumstances occurred. They notified the stakeholders. I think they even had the blood retested in Austin. It showed no alcohol, which was consistent with the no test result, shock. Staff had a recommendation to take no further action given the root cause analysis. And I guess I would just make a comment. I appreciate the analyst's candor. You know, if I didn't open it, I just don't remember it. And, didn't try to create something that didn't exist. So that's encouraging. Any comments, thoughts, ideas? If not,
I'm sorry, Mark, just to make sure we're standing, Brady, I can see you're on the line. So the way this was discovered is it went to Austin for drug toxicology, and that's when they realized it had not been opened. Is that right?
Yes, this is Brady Mills. Yes, the normal process for this case was to do the ethyl alcohol testing in Tyler, but then there was a request for drug tox as well. And so that tube was transferred to our Austin lab for further testing. And at that time, it was noticed that the seals did not look as if it had been open. And that's what started our process to try to take a look at what had occurred in the Tyler laboratory.
Thank you.
if no other thoughts or comments, I would this time make a motion, take no further action, given the root cause analysis and corrective actions by the lab.
Any other discussion? Is there a second?
Second.
All those in favor say aye. Aye. Opposed? All right, motion carries.
Let's bring us to our next self-disclosure, 20.44. It came out of NMS in Pennsylvania also. It's an incident in the forensic biology section where some incorrect allele values were used to calculate important statistical values in the case. The lab is still doing some ongoing work. Eventually, it involved calculation of statistical values in the DNA unit. It discovered during the corrective action investigation there were transcription errors in a few of the individual allele frequencies in the procedure for each software program. Some of the allele frequencies were calculated based on a sample size that was determined to be incorrect. So far, it doesn't look like it's going to affect any reported conclusions of profile comparison. The lab staff had said, let's wait and see what the lab does as far as their review, and they had requested projected a completion date around November 2nd of 2020. I think we have a meeting before then. So if we choose to simply table it, which is what I'm about to recommend, maybe we do not bring it back next meeting unless they completed their work through their internal investigation review. And maybe Dr. Logan could tell us if that November 2nd, 2020 date is still accurate. If he's on the line.
Barry, your line is muted.
Thank you. So yes, we're still committed to that November 2nd date. We have made an assessment of the resources that we have allocated to the review and remediation planning, and we do anticipate being completed by November 2nd, but probably not before.
Well, then I would, based on that, make a motion that we table it beyond our October meeting date to give them a chance to complete their investigation review and provide further information. I'll make this form motion.
Any further discussion? All right, do I have a second?
Second.
All those in favor say aye.
Aye.
Opposed? All right, motion carries.
Which will bring us to our one complaint we've had since June. It's number 20.08, brought by a lawyer out of San Antonio, Angela Moore, on behalf of defendant Laura Day. The complaint is against Andrea Zafaris. She's alleged expert drowning deaths. She had taken a case out of Nueces County in Corpus. It was a capital case of intentional drowning, intentional causing death. She made some findings as to the tidal waves, the time of high tide, low tide, the angle of the actual shoreline in her findings. She used some milk jug to replicate a child's body. This Moore had found 4 experts who disputed what she said, and they can't actually do that or actually make those type of findings as foul science. Her counsel had asked to respond to this. I don't think we received that yet, have we, Lynn?
No, we have not, but I expect we will before October.
Well, it's a fairly complicated case. I think it would only be appropriate that we wait for response by Ms. Zafaris and her counsel, and based on that, I would make a motion to table the complaint pending response from her and her counsel to our next meeting.
Yeah, I'm interested in seeing what response there is as well. It's kind of an interesting case. So is there any further discussion? Is there a second to table this?
Second.
All right, all those in favor?
Aye.
Opposed? All right, motion carries. That takes us to, that finishes our complaints. Thank you, Mr. Daniel. And next we move to item 7, which Lynn That's a discussion of the Office of Capital Writs and Forensic Writs.
So you may recall that the legislature incorporated a provision in both the government code and in our enabling statute that allows us to refer cases to the Office of Capital and Forensic Writs. And in your materials is a letter referring cases to date. And we just wanted to get a motion approving that referral. And then we will be periodically asking for approvals of referrals per the statute, which we will send to the director of OCFW, Ben Wolf, via letter.
All right, so is there a motion to approve the case referrals to the Office of Capital and Forensic Writs?
So moved.
Is there a second? All right, all those in favor say aye.
Aye.
Opposed? Okay, motion carries. All right, so item 8 is a discussion by Lee regarding the status of the Crime Laboratory Accreditation Program.
Each quarter, we summarize for you all the accreditation activities that have happened. So you have a memorandum in your materials that describes those activities. There was one in particular that as a complaint that was filed against the laboratory with A2LA. And in that complaint in particular, they were complaining about financial dealings of the lab. There weren't any allegations of forensic negligence or misconduct at all. So we included that with your accreditation materials because we felt it was important just to make you all aware if anything happens on the A2LA front, that we would have to take action on the commission side too. Lynn, did you want to add anything on that?
That summarized.
Does anybody have questions on any of the items in the memo? That should be it on that one.
Anything further? All right, so item number 9 is going to be an update. Lee?
So right now, just to give you a quick update on our licensees, we have 1,339 people licensed as either forensic analysts or technicians in the state. This year, licensing specialist, Rodney, and the rest of our staff will be renewing 1,007 licenses between now and December, which is going to be a huge undertaking. So we've been working on streamlining the process of approving CFE for that, and we appreciate those who have already applied for renewal, their patience with us in streamlining the process and kind of being the guinea pigs for that. But we think it's going to go well, and we're just ready to accept all the renewal apps. The next item here is a rule that we need your approval on. The rule just establishes a timeline for requiring the 8 additional continuing forensic education hours when you add a discipline to the scope of your license. Right now, if you added a discipline to your license, say 2 days before your license expired, you'd still have to get those 8 hours. So we just established a timeline here for requiring those hours. If you add a discipline between 6 and 18 months of your license expiration, if you add a discipline within 6 months of your license expiration, none of those 8 hours are gonna be required of you. If you add a discipline between 6 and 18 months of your license expiration, you have to do 4 hours, and then you got to do the full 8 beyond that. And we just thought that made sense. We had the issue come up with a license candidate that was up for renewal and was going to have to fulfill 8 hours if they added this to the scope of their license.
All right, so we're going to need a motion to adopt the rule addressing continuing forensic education requirements when adding a forensic discipline during the current license cycle. Do I have a motion? All right, do I have a second? Second?
Second.
Do I have a second?
Second.
think Jasmine.
Okay. All right. All those in favor say aye.
Aye.
Opposed? The motion carries. All right, Lee and Lynn are going to discuss the next part about nominations. I would like to say, since we're having two people stepping off, Greg Hilbig and Robert Sailors, and express our appreciation for the amount of work that they've done, especially since this was the beginning of creating this advisory committee, licensing advisory committee, and in particular, Greg for taking the bullet and being the head of the committee. So we'd like to express our appreciation to them and need to discuss some of the filling the two positions. Actually 4, but I think there's only actually, in the attorneys, there are only 1 nomination apiece. So we're looking at analyst positions.
That's right.
Right. So for the attorneys, we have Bill Hines from the defense seat and Callie Bailey from TDCA from Collin County. She's an assistant district attorney there. Both of them are willing to serve another term, so that's really great because it provides continuity. So those 2 seats are the easier seats. The challenging issue is always filling the scientist seats when we have a goal of trying to balance a whole bunch of different competing interests. So we want diversity of forensic discipline. We want diversity of the type of laboratory. So by that, I mean private versus state versus county versus municipally funded, mostly because we want to have just the diversity of size, for example, and then also experience. So we don't want all very, very senior people. We don't want all very junior people. So the challenge is to try to always patchwork together representation from various areas. So if you take a look at the candidate matrix, we have folks from Harris County IFS, we have Harris County IFS, an experienced toxicologist. We have Mike Ward, who has tremendous expertise in firearm and tool marks and also management. He's from Fort Worth PD. He has served on the LAC in the past. We have Sandy Parent, who runs the statewide comparative disciplines program at DPS. She is the only DPS candidate on here. And one of the reasons I want to point that out is because once Greg rolls off, we won't have anybody from DPS unless we replace Greg with another DPS person. And just to give you some idea, I was looking at the numbers today. Rodney Soward, our licensing specialist, was helping me with this. If you count every licensee in the state and all the blanket licensees who are outside the state, DPS licensees make up 30% of the population. If you look at only those who are fully licensed and not those in the blanket program, they make up 40% of the state's licensees. So they have a large percentage of their employees are affected. So I just wanted to mention that. Deborah Smith from Fort Worth PD Crime Lab, she's a latent print master's degree in forensic science. What I thought was interesting about her application is, as you know, we're trying to expand this program voluntarily to disciplines that are not currently subject to the accreditation requirement. That would include latent prints. And for those who've been here from the beginning, when we first developed the program, as you know, the Texas division of IAI reached out to us because they're very interested in having a credential through our commission for latent print. Digital evidence is another one that reached out to us. And then of course the crime scene folks. Aaron Spargo, who was at Swifts and now is at NMS, tremendous reputation in toxicology, has lots of experience. I mean, we have some great candidates. We have 3 folks from Armstrong. I think Armstrong has participated in lots of aspects of our licensing program, including test question creation. And I think they really would like to serve on the LAC. We do currently have a private laboratory representative in Elise Watts from NMS, but we have 3 great candidates from Armstrong. And then, as I mentioned, Callie Bailey and Bill Himes, who thankfully are willing to continue on in their roles. So with that introduction, I would just open it to the commission to discuss. So we have 2 seats for scientists, and Robert Saylor's was DNA. We are losing DNA expertise, but we do have Aaron Reet, who's in lab management now, but his original area of expertise as an analyst was in DNA analysis. And then Greg Hilbig, who has been in management at DPS for a long time, originally was in forensic biology as well, but it's been a while since he's done analytical work, bench work directly. So that's who we're losing, and we have great candidates. And the only other thing I would say is for this matrix, so a number of folks are rolling off the committee in September of 2021. So we could retain this list, and for those for whom we don't have seats right now, we could next year this time, if they're still interested, incorporate them in the process at that time. So that's all I have as in the way of introduction, and now you get to decide who you think would be the best to fill Robert Saylor's and Greg Hilbig's. I don't know, Greg.
I would definitely support the recommended slate of Deborah Smith and Sandy Parent. I guess my only reservation is I would like to see someone with tox experience, and my recommendation would have been Aaron Spargo for the reasons that you mentioned, Lynn, but I understand that in terms of maintaining the balance of organizations, we don't want more than one person from one laboratory sitting on the committee. So I would support Deborah Smith and Sandy Parent, but I would definitely want us to look at appointing Aaron Spargo when Elise Watts' term expires.
Well, I think we can probably address that in terms of what our specialties are at that time. I think DPS needs to be represented, and I think having a city lab such as Ms. Smith represents right now gives us a good balance. And again, since we have just 1 year to go, I think we can then look at them again and see what distribution we'll have. So I think we have a lot of really excellent applicants. So I think that's a good point. So are you making that in form of a motion?
I'll make that in the form of a motion. To appoint
Is there any discussion?
And Sandy Parent.
Is there any discussion, further discussion? All right, do I have a second?
Second.
Second.
All those in favor say aye.
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 Any opposed? Seeing as there's none, then the motion carries. So the new members will be Sandy Parent from DPS, Deborah Smith from the Fort Worth PD lab.
Can you please also take a motion to keep our lawyers on for a second term? Great.
Sorry, when there is no replacement, I didn't even think about that. Yeah, so we need a motion, which Mr. Daniels made, to retain the 2 attorneys, both criminal defense and prosecution, on the committee. Is there a second?
Second.
All those in favor say aye.
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 Opposed? Okay, motion carries. Item number 10. This is an update on development and launch of mandatory legal and professional responsibility training.
Yes, so Robert and I recorded all of our slides on both Brady and the Michael Morton Act for forensic applications and the Code of Professional Responsibility. we've sent all of that off to Sam Houston. They have course designers who help make the presentation far less boring than it would have been with just Robert and me talking. And they integrate quiz questions throughout. And they put a video in there, and they're sort of fine tuning all of that. I expect within about 10 to 14 days, we will have that ready to launch. For those people who are already in the process of renewing their licenses because they got licensed early, their licenses are being processed regardless, and then they will just need to take that when it becomes available. But we think it should be soon. It's not a small undertaking because they're creating it in a way that makes it look very professional, and then folks can take that. I'm not sure the final number of hours after they put it all together, but based on what Robert and I did, I think it'll be somewhere between 2 and 3 hours, and everyone can take it from home. It's an online course, and then upon completion, they'll be done with that element of their licensing requirements. So I don't know, Lee, did you want to add anything else to that, or is that it?
That pretty much sums it up.
Okay, so that's all I had there. Any questions about that? We will send it around to commissioners once it's done, because I think it would be good for folks to see what we did. I mean, Robert worked very, very hard to get case examples, forensic science case examples around the country. And we integrated some items that we've reviewed here at the Commission. So I think we're also going to distribute it to TDCA and TCPLA when it's done, because I think they'd like to see it as well.
Any further discussion? All right, let's move to item number 11. That's going to be Dr. Kerrigan regarding the final stages of interlaboratory validation, distinguishing hemp and marijuana.
So essentially this project is finished in the sense that the validations are complete. This involves 3 accredited labs, the Houston Forensic Science Center, Harris County Institute of Forensic Sciences, and DPS. SHSU have been facilitating this project over many months. Currently, the validation data is really sitting with quality divisions within those various organizations. We have 2 documents that we're intending to send to the TACLID as soon as the labs get approval to release data from their quality divisions. The 2 documents are procedure, which is the framework that the labs are using, and also a summary, a composite of all of the assay performance between the 4 sites, HFSC, HCIFS, DPS, and Sam Houston State University. So in terms of implementation, I'll let the lab speak to that, but it is my understanding that DPS are planning to implement early in August, and the Houston Forensic Science Center are planning on August 31st or thereabouts. So we're looking at, I think, August deployment for most of the agencies. The other thing that we've been doing, we had a meeting yesterday with ANAB, we're trying to harmonize the reporting language that would be used between the different sites, and we're going to include that in the procedure document should other labs want to adopt similar reporting language, that they can do so. So that's pretty much an update. I think we're still continuing to meet weekly on this project. We've been meeting weekly for a long time now, but essentially, of course, all of the lab work is done. It's just sitting with quality divisions for review. So I'm not sure if any of the labs want to add anything to that update.
Peter?
Yeah, I think I was going to circle around with Brady and Roger here today and just double check dates. I think what we had talked about for Harris County was in Harris County launching all at the same time to try and make life as easy as we can for the DA's office. But talking talking with Roger this morning, I mean, it sounds like we're all kind of there. The August 31st launch seems pretty reliable that we can get that to happen. So keep your fingers crossed.
I guess the one other thing I would add is that we do have materials, known materials available to the labs, accredited labs in Texas. We've only had one request. Remember, those requests have to go through the TACLID, so those requests go to PETA, but there's only been one request from a lab for materials. So I would encourage labs that are planning to implement a procedure to make use of that and reach out to PETA.
I'll send that out again to TACLID here.
Yeah.
Dr. Kerrigan, did you want to say anything about NIST's project where they're going to be providing materials, I guess, they're emphasizing liquids, and that may be a good place for accessing materials once that component of validation starts?
I can make a couple of comments. So NIST do have a project currently, and they are planning to make materials available to labs. It will be a study. The first samples that will be available will be liquids, however. And I believe there, as of the last meeting that I was at, the plants were anticipated to be available sometime in October. But that is also potentially a source for labs if they want to collaborate on this NIST project. And what we can do is we can get the information once that's firmed up and the dates and the information is available from NIST. We can make that available through the commission and push that out through the TACLID.
Thank you.
And this is Brady Mills with DPS. Just to give an update of where we're at as well. First, this was a great effort to get all the labs together in Texas and partnering with the two labs in Houston and Sam Houston State to kind of get this heavy lift completed. We do feel, and we are planning on sticking with that original date of August 3rd. And so we feel our documents are with our quality department now, and they're being reviewed. And if that process goes well, which we anticipate that being so, we'll be able to work cases that first week of August in the 4 laboratories that will be part of validation. So that would be Houston, Weslaco, Corpus Christi, and Amarillo. And then our other labs, we will walk through the state and turn those on as we walk through. That is our update as far as the differentiation between marijuana and hemp.
Roger, did you have anything from HCIFS?
Yes, I think we're going to coordinate with HFSC and try to start the same day they do, regardless of who's ready first. So we're going to coordinate locally with the county, and Dr. Stout and I will ensure that the date is the same. And I agree with his comments that it would be in August.
And then I think the final thing was, Dr. Logan, I didn't know if you wanted to say anything about the process you've undergone with your own method and sharing of information regarding some challenges there.
Sure. So we have been running the hemp marijuana differentiation test for about 6 months now, based on the same model, the DEA hemp marijuana differentiation model that the Texas labs have been working on. It's been we've run close to 2,500 cases. Maybe about 5% of them have turned out to be less than the 1% threshold. The remainder above. We do have a quantitative measurement or assay that we've applied to some of the samples that have been less than 1%, but the majority of them are, in fact, less than 0.3% when they go through the full quant procedure. So We're currently working on a full quantitative method for other matrices. Our current method we use for plant material, for e-liquids and oils. The edibles don't work well in that method, and the waxes don't work well in that method, but we have another method, completing validation, that we hope to have online at the beginning of September that would be suitable for all matrices for full quantitation. The other thing we've gotten requests from our staff from is just some advice or guidance on testimony and what they can and can't say about this qualitative, positive or negative around a cutoff. So we're working on a training program to help prepare them for the kinds of questions they might get.
The one thing I wanted to say about that is I am going to be talking to Shannon Edmonds next week from TDCA about training for prosecutors around the state. And, you know, originally, certainly it was envisioned that the training would go to the method, the specific method that Texas DPS is rolling out, since the volume is so high with DPS. I do think it would be worthwhile to talk about training in a little bit more of a coordinated way, and whether there are possibilities for people to understand. I mean, I think general concepts are probably about as much as one can expect the lawyers to grasp, but we should probably talk about ways of doing that in a coordinated fashion, as opposed to sort of scattered. So it would be good. I mean, I would rather have more training than less, especially on testimony. And, you know, an issue that the HFS disclosure brought up earlier on is, you know, they're looking at transcripts. They are actively looking at their transcripts. And that, to me, is a hugely beneficial undertaking, because there's a lot of stuff that comes out during testimony that may not be obvious in a report. And so, you know, to the extent that we can help analysts, especially understand and appreciate the limitations of analytical methods and not end up getting walked into a corner, or otherwise, you know, lawyers will ask questions trying to get to brass tacks, and you can't always do that with forensic science. So I'm going to leave my monologue now and just say that, yes, we should all talk about training analysts in new methods, and in all methods, but especially in new methods.
Well, and I think this has been especially important for this particular test, because it is effectively a semi-quantitative test around a cutoff, which is different from the majority of the cases that our analysts do, which are qualitative. We do have other individuals who are trained on quantitative procedures. But just the idea of going from testifying about a qualitative determination to a quantitative determination is something that they're appropriately asking for help with. So I had reached out to Peter just this morning to tell him I'd be happy to work with the TACLAT group and share our experience of that.
Thank you.
Anything further? All right, next is item number 12, discussing the recommendations from the investigative panel regarding NMS labs from Grand Prairie and the seized drug. Mr. Daniel, Dr. Kerrigan, Mr. Johnson are the members of that committee.
So I have a PowerPoint presentation that I'm going to walk through the facts of the self-disclosure, and as well as the actions taken by the investigative panel and the recommendations in the draft report. So Lee, if you could assign the screen to me.
Yeah, you're the presenter now, so you should be able to show your screen.
Okay, so okie dokie. It should be coming up, hopefully.
There it
Can
is.
folks see what I'm doing. Okay. All right, so can everybody see my PowerPoint now? It looks good. Is it
I
showing?
see a blank screen.
Huh, okay.
You had, it was up a minute ago.
There it is.
There.
Okay, let's see if I do play from start.
Yeah, it goes white when you press play, so maybe just click through the slides like that.
Okay, so let me try this. I'm sorry, I think I know what's happening technology-wise. I'm gonna restart this. 1 second. I think I chose screen, share, and all right, so how about now? Is that good?
Looks good.
All right, so pardon me for the technology issue, but we're gonna get going here. I have probably about a dozen slides to just walk through the basic facts of the self-disclosure. So to refresh everyone's recollection, under 38.01 of the Texas Code of Criminal Procedure, laboratories that are accredited to perform forensic analysis in the state of Texas must self-disclose incidents of professional negligence or misconduct to the commission. And this particular example is a self-disclosure by NMS. This was the NMS laboratory in Grand Prairie, Texas, where the incident occurred. And so they self-disclosed this to us as they're required to do by law. And what happened was that back in September of 2019, NMS was actually in the process of releasing the new analytical method that we just discussed in the prior agenda item. So they developed a qualitative method with a quantitative cutoff for distinguishing hemp from marijuana, as they're doing across the country. But in Texas, we have the legalization of hemp that just occurred during the last legislative session. So NMS's method follows on the heels of what the DEA has done. And so everyone's familiar with the method. And what happened was, as they were rolling this out in September of 2019, the laboratory held continuing education for their seized drugs analysts, including those in Grand Prairie, focused on why they had developed this qualitative method with the quantitative cutoff, what the process for the method was, and a lot of that continuing education focused on how to perform the assay and things to be conscious of in that process. They had on-site training in Grand Prairie, which included sample preparation, setting the runs up, processing data, and reporting. And after that training was done, the laboratory supervisors and the training manager distributed competency training samples to the analysts. So this is typical. You take a competency test in order to be qualified to perform the assay in actual casework. So a licensed analyst at NMS, she's licensed in the area of seized drugs, manually integrated the THC peaks in her control sample. And what that did was it resulted in a smaller peak area and therefore a smaller quantitative value assigned to the sample THC. And she only did that with the THC peak in the control and not with any other peaks in the unknowns or the calibrators. And this was observed by the training specialist. She noted this when she reviewed the original data files that the analyst provided, and she looked at the auto integration parameters that were saved in the GCMS and realized that the auto integration drawn by the software was appropriate, and the resulting quant value of the THC control would have been outside the acceptable range had the auto integration been used. But because the analyst manually integrated the THC control, the quant value was brought into the acceptable range, and this allowed what would have been a failed run to pass. And so the analyst, the training specialist or the training manager and the supervisor looked at all of this, and they brought the analyst in to talk about the competency test and the manual integration that she did. And she stated that she checked the controls and saw they were outside the acceptable range, but the samples were due. She had a lot of other things to get done, and so she manually integrated the controls to bring things within range so her run would pass. And the supervisor and management at NMS asked the analyst if she understood that this was unacceptable, and she said she did understand. Her supervisors removed her from casework, and she left NMS in October of 2019. And if you look at this bullet, the laboratory determined the root cause was the analyst's choice to inappropriately manually integrate a control to get a better result because the competency test was due and she had pressure or perceived pressure from other work duties. But when we spoke with the supervisor and the training specialist, they indicated that she never asked for more time or indicated that she felt time pressured. She just took this action. And the reason why, you might say, well, why would somebody do that? And the answer was that in terms of actual impact, she would have had to rework it if she had not manually integrated that THC control. And so back at our January 2020 quarterly meeting, the commission accepted this disclosure to investigate. And to be clear, what we're looking at is whether the laboratory's finding of professional misconduct is sustained, because that could have implications for the analyst's license. And so the staff notified the analyst of the ongoing investigation. We've notified her in February and then again in May. We haven't received any correspondence at all from the analyst, not in writing, not a request to speak with us. We've heard nothing. And we gave her a 30-day deadline also to respond. That deadline was June 15th. We have not heard from her. At the end of May, we talked, as I mentioned, to the direct supervisor for the analyst and the chemistry technical lead, who was also involved in the training for this particular analytical method. And those interviews confirmed the information that NMS had provided in their written disclosure. And we asked, and I'll let the panelists contribute their impressions as well, but one of the specific questions that was asked was, were other people feeling time pressure? I mean, as Dr. Logan mentioned a moment ago, this is not something that they typically do. A lot of analysts are used to doing the qualitative assays, but the introduction of a qualitative assay with a quantitative cutoff. And so we were wondering if others raised questions about either relative difficulty of the test or lack of understanding or time pressures. And the supervisor and training manager indicated that while, some analysts did have questions and did raise issues about the assay, none of them said that they were unable to complete their competency sets due to time pressure or overloads in casework and other areas. So I'm going to pause for a moment just to allow members of the panel, and that would be Pat Johnson, Mark Daniel, and Sarah Kerrigan. If you have anything that you'd like to add to my description of the facts, that would be great. And then we'll get into sort of some of the legal analysis.
Lynn, Mark Daniel, no comment. It's very comprehensive.
Yeah, I don't have anything else to add, Lynn. Thank you.
I have nothing to add either. This is Pat.
Okay, thank you. One thing that I should note is that Pat and Sarah both looked at the chromatograms to make sure they understood what it was that NMS was seeing in the data. So that review also occurred. And we had asked NMS to provide some additional data, and they did that. And so it was, in addition to the interviews, there was also a review of the relevant underlying data. So just to be clear, I wanted to refresh everyone's recollection about the definition of professional misconduct, which is found in the Texas Administrative Code, and it means that the forensic analyst or crime laboratory, through a material act or omission, deliberately failed to follow the standard of practice that an ordinary forensic analyst or crime lab would have followed. The deliberate act or omission would substantially affect the integrity of the results of a forensic analysis, and the act or omission was deliberate if the analyst or crime lab was aware of but consciously disregarded an accepted standard of practice required for a forensic analysis. Now, when we're dealing with disciplines subject to accreditation, like seized drugs, the standards of practice are fairly easy to identify. So it makes this analysis, I think, a little bit easier. I should note that this was done in the context of a competency test. So it raises questions about what the term would substantially affect the integrity of the results. What does that mean? And the commission has always maintained that it doesn't require the criminal case to an actual impact on a criminal case. That is rare, that the misconduct would actually impact the criminal case. It does happen, but much less frequently. But what we're referring to are acts that would call into question the integrity of the forensic analysis, the analyst, or the crime laboratory. So looking at the Code of Professional Responsibility, which is found in 651.219 of the Texas Code of of the Texas Admin Code, there are a few different items that we believe were implicated by this decision to manually integrate the controls in order to get through the competency set so that it didn't have to be redone. One includes the requirement that analysts promote validation and incorporation of new technologies, right? So as new technologies or methodologies get brought online, it's important that that be done in a way that has integrity. Secondly, when we're talking about examining evidence in seized drugs or any place else, the work, it needs to be done in a fair way and a thorough way, and the opinions and conclusions need to be objective, and that's difficult to do if you are sort of cheating on the sign-off that the laboratory is giving you to be able to run the method independently. And obviously with the third bullet, what we don't want is outside influence to impact the conclusions or procedures. They need to be supported by sufficient data, regardless of whether you might have, so in this case, the outside influence could be perceived as that time crunch. And so we want to make sure that people understand that even if you're under a time crunch, the appropriate step to take is to go talk to your supervisor about that and not to just manipulate the data so that you can get through it. And then obviously we always want to present accurate and complete data in any way that we communicate it, whether it be in reports or oral or written presentations. It all needs to be done based on good scientific practice and valid methods, which is what NMS's method would have done had the data not been manipulated by the analyst. So here we have, just to let you know, with respect to how things proceed now that we have a license program, we have a method for analysts to appeal any adverse finding. So the draft report in this case sustains NMS's reporting of this disclosure as professional misconduct. And what we want to let you know is that we have rules in place that would allow the license holder to appeal that through the JVCC. Don't we haven't heard from the license holder at all. So to date, we have not, and she was given the information that we had. To date, we have heard nothing, but it's possible that that could be part of the subsequent process. And then once the commission determines that a license holder has committed professional misconduct or otherwise violated a rule or order of the commission, and those rules and orders are set forth in the Texas Admin Code, so the commission has a number of options: revoking or suspending the license, refusing to renew the license, reprimanding the license holder, denying a license affirmatively, or placing someone on probation if their license is suspended. And then this next slide talks about different options for suspending or probating a license. And so there's many things that we could require if the commission were to decide to put the individual on probation. And then in terms of the appellate process, once the commission determines what the conclusion is with respect to professional misconduct and as well as the actions that may be taken on the license, we need to send notice through our process, including a summary of the misconduct or violation, a statement of the action taken by the commission, and then information about the analyst's ability to appeal through the JVCC, which is another commission in the judiciary that the legislature has delegated as the appellate body for our findings. So that's everything, both in terms of that process. Once the licensee receives notice, they have 20 days to request the hearing before JVCC. And if the license holder were to come back and say, hey, I didn't get anything you sent, I never saw any of it, but now I have it, and I'd like to talk about some form of stipulation or agreed settlement, we would still be able to do that. The Texas law prioritizes and gives great value and weight to settlement in any of these procedures. So there's always an option if she were to come back and ask for something different than what the commission ultimately decides is appropriate. So that's everything I have on, and I'm going to exit out of my screen here. But ultimately, you have the draft report in front of you, and what I think the commission needs to decide is whether or not the findings in the report are whether it's something that you're ready to accept, and that would include both the professional misconduct finding and the recommendation on license revocation.
Do we know whether this analyst is still functioning as an analyst or is, somewhere else, not even practicing in the same area?
I don't think we know that.
Okay.
Yeah.
All right, just curious.
Lynn, this is Mark Daniel. Shouldn't we do this two-step process? First off, make a decision about whether expecting misconduct, and then a second item to determine what the corporal sanction might be?
Yes.
All right, so we have two motions. The first would be whether to accept the findings and recommendation of the final report, which includes a recommendation for professional misconduct.
So moved.
Do I have a second?
Second.
All those in favor, say aye.
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 Opposed? All right, that is passed. The second would be whether we have discussion or whether we have a motion for the analyst license to be revoked. Does anybody have any discussion on this? All right, hearing none, do I have a motion to revoke the analyst license?
Dr. Lord, I'll make that motion.
Do I have a second?
Second?
All right, all those in favor, say aye.
Aye.
Opposed? All right, motion carries. All right, the 13th item is an update regarding Signature Science involving an investigative panel with Mr. Johnson, Mr. Daniel, and Dr. Drake.
So if you recall, this is a self-disclosure from SCI about the backdating of a sexual assault kit that came in to SIGSI and was not opened, and then evidence check initialed and backdated the date to when it should have been opened and not opened. So this was self-disclosed because the analyst is not licensed. She requested to speak with us, so we did have an interview with her discussing the facts in the case. And we still need to speak with a few people from SIGSI, and we're setting up those calls. So we should have a further update for you at the next commission meeting.
Right, is there any further discussion? All right, number 14 is the discussion with the sexual assault kit backlog reduction. Dr. Downing?
I was going to actually ask Dr. Badoli first to talk a little bit about the statewide sexual assault task force, and then Dr. Downing and I can talk about some other recommendations on pediatric sexual assault examination.
Sure, I can give you a quick update. Also, Jarvis, I don't know if Jarvis is here. I don't know if he is, but he's also on the committee. It's actually pretty impressive, demanding group run by Hillary Eglund and Nicole Martinez and Francesca Garcia. They've been organizing it, and it's to address issues around sexual assault survivors and better ways to process evidence, better ways to deal with trauma for victims and be victim-centric. And so it's reviewing all aspects of the forensic work, the exams, the interaction with the victims, and I'd say one thing, quite demanding.
And how long, what is the work product? Is it going to be a report to the legislature before when they start session, or do you know that?
Well, what they're working on now is actually looking at current protocols for all aspects and looking at line by line guidelines or standards and modifying them accordingly as necessary to improve the process. For example, and Brady was involved in one of the discussions, just whether you pluck hairs, pull hairs, cut hairs from a victim, which is more important, should you even collect the evidence, can be an example of how depth they're going into this effort.
Okay, thank you. And then if there's nothing else on the statewide task force, I wanted to mention that Dr. Downing and I had spoken since our last meeting. If you recall, she had put together a number of recommendations as a result of her review of a case that we had come in. And the main issue really from, I think, lawyers' perspective is understanding, first of all, what makes a pediatric sane and an actual expert, and providing ways for those cases to be vetted by an actual expert, providing methods for doing that are accessible to the community that needs the help. So we had talked about two different things. One is that we're going to be speaking with Dr. Nancy Kellogg, who is one of the authors of one of the main classification documents, or perhaps the only classification guideline document when it comes to the medical evaluation of children who are being observed to assess whether sexual assault may have occurred. And then the other person that we're looking to talk to is Justin Wood from the Children's Advocacy Centers of Texas, because they're very much involved in these types of cases. Justin has been involved in criminal justice for many, many years. He's currently the general counsel of that organization. Formerly, I believe, worked for Senator Whitmire, and before that was a prosecutor. So he understands the implications of criminal law for sure, as well as, you know, Michael Morton and Brady and those things. So that's what we're working on. It's slow going, but we want to see if we can't help facilitate some of these conversations and move things forward in a way that will help everyone involved. So Dr. Downing, did you want to say anything else about that, or?
No, I think that you said that exactly right. Our concern is that we just want to make sure that people who are conducting these exams, interpreting those findings and testifying about them are truly prepared to do that in an evidence-based way. And it has to be done carefully, though, because there are a lot of people practicing as pediatric SANEs in the state. We want to make sure that we are engaging them in a way that promotes trust, and it's not, you know, it's not a critique of their work. It's trying to improve the quality of it.
Thank you.
Is there any further discussion? All right, well, the next topic is an update from the Texas Association of Crime Lab Directors. Dr. Stout.
Thanks. We met on Wednesday. I think it was our first completely virtual meeting. We've done a couple where we've always had virtual attendees, but we did it completely virtually. It was actually pretty successful. We had pretty good attendance. I think notably we are up to 45 regular members. We still have about 18 voting members, but we have seen a fair expansion in the membership with a lot of quality directors and others in laboratories that are now part of regular members. So I think TechLab continues to expand to be a good route to reach into all of the laboratories in the state. I think other major components that we talked about, Don Boswell has put together a document of recommendations around video testimony. I know we've seen in Houston, I think we've seen one significant testimony toxicology case here just really recently, but I think it's still pretty spotty of how many video and remote testimonies anybody's seen. But Dawn did a nice job of helping with some of the recommendations around it, some of the framework of what video testimony is, isn't authorized, not authorized. We voted in 2 new members, and we re-elected Elise Watts as secretary. So Elise is on deck for another couple of years to try and keep us on track.
All right, thank you. All right, we're at item number 17, and that's to schedule the next meeting, which is scheduled in October. Or do we know if this is going to be Zoom or in person? Now, I'm inclined to think it's probably going to be just not Zoom, but I mean, as we're doing remote, just like now.
I think that's less.
Yeah, so do I. All right, so item 18 is the public comment. Catherine?
We did have a lawyer in the chat room that represents Andrea Zafarez, Jerry Morris, or Gaines West. Either of you want to? I don't know if they're still on the call.
No, they left the call as soon as we tabled the complaint.
All right, if there's no one that wants to speak, that's the only inquiry it looks like that we got.
All right, well, that simplifies it. So do we have any further discussion by anyone? Hearing none, do I have a motion to end the meeting?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? All right, motion carries. Thank you all for attending. We'll be chatting again in at least in October. Lynn, anything else you have to add?
No, thank you, everyone.
Thank y'all.
Thank you.
All right,
Bye-bye.
thanks. Have a good day.
Bye. Thank you.